Good evening. I'm attorney Harold Weiser with the Weiser Law Firm, and I'm taking a moment out here to discuss an arrest and the bail and the family or that person now has the option of bonding that person out. Well, they can come up with $20,000 cash, but most people don't have $20,000 cash, and they go to a bail bonds agent. What a bail bonds agent does is they post what is assumed to be a commercial surety. That particular bail bonds agent uses an insurance policy that they have, signs up for that insurance policy on that person, and then that will cover their $20,000 amount. Now, different bail bonds agents charge different prices. I've seen anywhere from 5% to 20%, depending on the amount of the bond that is set. I've also seen bail bonds agents not willing to take somebody's bond because the amount may be so low. It may only be $500 or $1,000. And some people get caught in that in-between scenario, and then they may call an attorney, and the attorney can talk to the judge. The judge on certain crimes can issue what is called an ROR, or release on their own recognizance. And this is for non-violent, non-sexual offenses, generally first-time offenders. Sometimes the judges will let people out on their first offense, DWI, or a drunk in public, or something of that nature, or a simple possession charge. They will not do it and cannot do it on anything violent, like battery of a police officer, or a robbery, or a burglary. Any of those things, they cannot issue an ROR, and the Code of Criminal Procedure does not allow them to do so. The other two types of ways that people can be released are what are called personal sureties. That is when somebody in generally the immediate family comes and signs for that person to release them. And the courts tend to ask for some pay stubs or a 1040 to show that that person has an actual income. In the event that the person does not appear in court, that surety, their family member, would be then responsible for that $20,000. Finally, there are property bonds, which are more of a complex scenario. It's a 10 to 12 step process, from going to mortgage and conveyance office and verifying that there's not a mortgage on the property, or if there is a mortgage, the said value according to the appraisal of the property can substantiate the differentiation of the amount, in this case $20,000. And this process has to go from criminal district court to mortgage and conveyance to the assessor's office, back to mortgage and conveyance, back to criminal district court, and cost anywhere from $200 to $300 to file that. Again, it's generally not used for violent crimes or for any type of sexual offenses, but a property bond can be an excellent way to get somebody out of jail if they need be. Attorneys such as myself, and here at the Weiser Law Firm, and other criminal defense attorneys generally offer what are called bond reduction services. That is where we go either for the initial appearance, when a person's initially arrested, or right thereafter, and request to that magistrate or commissioner judge to reduce the bond based on the facts, based on the family, based on the lack of criminal history, any of those things. We also file, or can file, a motion for a preliminary hearing. The code allows a person who is charged with a crime to be entitled to a preliminary hearing. This is a hearing before discovery is released, and this is a hearing before any major work has been done from the district attorney's office on the case. This is a pre-indictment or pre-bill of information filed preliminary hearing. And this can be very beneficial because if a person is found to have no probable cause on the crime that they're committed, they can be released without paying the bond or without paying any bail bonds agent. It also gives us a scope of where this case is headed and how serious the facts may be upon the initial arrest. Once a person's arrested, the district attorney's office has 60 days to file a bill of information against the person, or 60 days to have a formal grand jury indictment against somebody. If they do not, defense attorneys generally file what is called an Article 701 motion for speedy trial to have a person released because they're being held unlawfully after that period of time, and a hearing will be set. Generally, once you file that motion, the district attorney's office gets their stuff together and will, in fact, file their bill of information if they have the facts that are necessary to do so. If a person has been bonded out, they have 150 days, the district attorney's office, to accept those charges or to file an indictment against somebody. If not, they would be released from their own bond obligation. And these are all determinations that are made with the screening department at the Jefferson Parish and Orleans Parish District Attorney's Office. And I generally highly recommend that a person hire an attorney prior to the screening process, right after the arrest, because it gives us the opportunity to file for these bond reductions, to file for preliminary hearings, or to discuss with the district attorney's screening department what these charges would be prior to acceptance. And sometimes we can work these things out via diversion programs or anything else, to where these charges may not wind up in the courthouse itself. And these procedures are very beneficial to the clients themselves. In a future lecture, I will talk more about how the screening process works. But again, thank you very much for joining us.